So on June 14th, the U.S. Citizenship and Immigration Services released new policy guidance on the eligibility criteria for initial and the renewal applications for employment authorization documents for something new. It's called compelling circumstances. So there's now a whole new group of people who may be eligible for work permits. Now, this is the group. For the applicant to be eligible for the new work permit based on compelling circumstances, got to meet the following requirements. The principal applicant and their family members, but would be all eligible for the work permit, but you have to qualify based on the principal applicant. The principal applicant has to be the principal beneficiary of an approved I-140 visa petition, which is the Immigrant Petition for Alien Worker, and be approved either in the first, second, or third preference employment-based category. So that would be your EB1 workers, your E2 workers, your EB3 workers, not your special immigrant religious workers under 4, and not the investors under EB5. So it's EB1, 2, and 3. And the principal applicant has to have that I-140 approved and also be in valid E3 status, H-1B status, O status, or L status. And then they can file a Form I-765. And the principal applicant also has to show that no adjustment application has been filed. Who is this going to help? It is going to help people who got sponsored in jobs for their green cards but can't file their adjustment of status yet because the priority dates have not been reached. Now, you got to show an immigrant visa is not available to the principal applicant based on the applicant's priority date, according to the final action date in the U.S. Department of State's visa bulletin. And as I said earlier, also family members, spouse, and children also can qualify. And if immigration determines in the matter of discretion that you have compelling circumstances to justify the issuance of a work permit, even though you have not filed your adjustment of status application, you and your family can get work permits. Now, this guidance covers compelling circumstances for the principal applicants and, as I said earlier, their dependents, the spouse and children, and provides a list of situations that could lead to a finding that compelling circumstances exist, including serious illness and disability, employer dispute or retaliation, or other substantial harm to the applicant or other significant disruption to the employer. And this guidance also provides details on evidence an applicant could submit to demonstrate compelling circumstances. For example, a principal applicant with an approved immigrant visa petition in an oversubscribed visa category or chargeability area who has lived in the United States for a significant amount of time could submit evidence such as school or higher education enrollment records, mortgage records if they own a home, long-term lease records to support a potential finding of compelling circumstances. Compelling circumstances could include if, due to a job loss, the family may otherwise be forced to sell their home for a loss, pull their children out of school, or even relocate back outside of the United States of America. This is especially going to help people in oversubscribed areas, Philippines, Mexico, India, and China, but all oversubscribed employment areas. On June 13th, the Department of Homeland Security announced the rescission of the prior administration's termination of the temporary protected status designation, and a lawsuit filed in federal court by advocates challenging the Trump administration's attempts to terminate TPS will now likely be deemed moot. So basically, Trump ended the program, Biden put it back into place. And this action will extend through 2025 the temporary legal status of more than 300,000 immigrants from El Salvador, Honduras, Nepal, and Nicaragua who have faced the risk of deportation and loss of work permits under the Trump administration policies. Secretary of Homeland Security Alejandro Mayorkas said, through the extension of temporary protected status, we are able to offer continued safety and protection to current beneficiaries who are nationals of El Salvador, Honduras, Nepal, and Nicaragua who are already present in the United States and cannot return because of the impacts of environmental disasters. Soon to be published Federal Register notices will explain the eligibility criteria timeliness, and procedures necessary for current beneficiaries to re-register for TPS and renew their employment authorization documents. Once the notices are published, existing TPS beneficiaries under the 4 designations will be able to re-register to continue their TPS throughout the 18-month extension. Individuals who arrived in the United States after the continuous residence dates for these designations are not eligible for TPS, and if they enter without legal authorization and do not have a lawful basis to remain in the United States, will be subject to removal. Today is June 19th. It is Juneteenth. Juneteenth is the oldest known U.S. celebration of the end of slavery, dating back to June 19, 1865, when enslaved Black people in Galveston, Texas, learned that they had been emancipated close to 2.5 years after the Emancipation Proclamation had formally been put into place. While Juneteenth is the oldest known celebration of the end of slavery, this holiday has not been recognized as a federal holiday until 2021, when President Joe Biden signed the Juneteenth National Independence Day Act into law after the efforts of former Texas State Representative Al Edwards, who sponsored the bill that made Juneteenth a state holiday in 1980. Lobbyist Lula Briggs Galloway, Texas activist Opal Lee attended the presidential signing of that bill into law, and others as well. And while this holiday becomes more mainstream, it is important to recognize Juneteenth's place in American history and to reflect on the long struggle for equal rights. And I'll be honest, you asked me 10 years ago, put my hand on my heart, I did not know anything about Juneteenth. About 10 years ago, I started learning about it. And in the last decade, it's become extraordinarily mainstream. I think in another 10 years or so, it's going to be, well, I think it's mainstream now, but it's going to be completely mainstream. I mean, everybody I know, regardless of race, nationality, color, all are very well aware of it, all mostly support it, all are celebrating it. Treshawn Dennis Brown, a legal columnist for probono.net, wrote a very important piece highlighting what Juneteenth means for him personally, and I thought we would share it here. Dennis Brown wrote, although at first embraced solely by African American communities, Juneteenth has gained traction among mainstream outlets in recent years, garnering state and local recognition across the country, especially as the country comes to grips with a legacy of racial tension. But who is Juneteenth for? Juneteenth can be said to be a holiday celebrating Black liberation, but it's important to remember that many heritages simultaneously reside under the blanket term Black. Dennis Brown wrote that he is a proud first-generation American with heritage deeply entrenched in the Caribbean, boasting primarily Jamaican but also Trinidadian lineages. As such, I sometimes feel as though my plight is somewhat divorced from that of Black African Americans, as I cannot lay claim to the legacy of American chattel slavery in the same way. Instead, I hail from islands that were colonized by the Spanish and British, each nevertheless saturated with their own horrors, commensurate with the reputation of being sugar colonies in the colonial era. Is Juneteenth just for the African American whose lineage could, or more realistically could not, be traced back to American slaves? He continued by saying, despite identifying as a first-generation Caribbean American whose family immigrated to the United States in the 1990s, he and his family are easily welcomed into the fold of Juneteenth celebrations. He says the ease with which this happens is possible due to the shared connection of the pigmentation of their skin. The fact remains that despite ancestral differences, the plight of Black people, regardless of immigration or residency status in the United States, is almost universal. Black people retain the lowest median income, are currently enjoying the lowest rate of Black home ownership since the 1960s, and are disproportionately stopped, arrested, and even sometimes fatally killed by the police. He writes that while this might seem the grimmest of ways to endear oneself to a holiday, he is nevertheless excited that Juneteenth is now recognized nationally. And I will say on a side note, not only recognized nationally, but becoming mainstream, which is extraordinarily important, being accepted by everybody. And he closes by saying that the intellectual divide over whom Juneteenth belongs to will hopefully fade over time as Juneteenth continues to attract interest in the mainstream. Soon the question will not be whether Juneteenth is just a black holiday, as Americans as a whole continue to embrace it as a holiday along with all the other stalwarts, 4th of July, Memorial Day, and the like. On Thursday, June 15th, the 11th anniversary of the Deferred Action for Childhood Arrivals program at DACA, a group of bipartisan lawmakers in the House relaunched efforts to provide a legal pathway to citizenship for millions of undocumented immigrants. At a press conference Thursday, the group of lawmakers from both parties announced the reintroduction of the Dream and Promises Act, a bill aimed at creating a pathway to citizenship for Dreamers, undocumented immigrants who were brought to America as children. It also includes provisions of those with temporary protected status and deferred enforced departure status. House Minority Leader Hakeem Jeffries, a Democrat of New York, said, "This is not simply a Democratic issue or a Republican issue. It shouldn't be viewed as a partisan issue at all. Standing with Dreamers, standing with TPS recipients, standing with those who deserve a pathway towards citizenship is an American issue, period. Full stop. America is a nation of immigrants. We are a gorgeous mosaic of people who come to this country from all throughout the world." The bill was introduced in the last Congress by then Representative Lucille Roybal Allard, a Democrat of California, who retired at the end of her last term. The bill passed the House in 2021 with some Republican support, but it died in committee in the Senate. Representative Lori Chavez DeRamier, Republican of Oregon, said, "This is a historic solution that will provide overdue protections for Dreamers in the United States, protections that more than 70% of Americans support." According to a fact sheet obtained by Spectrum News, the Dream and Promise Act would grant Dreamers conditional permanent residence status for 10 years and cancel removal proceedings if they have been continuously and physically present in the United States since on or before January 1st, 2021. So it would basically apply to anybody who would have qualified for the Dream Act had DACA passed this moment. The bill would apply to those who were 18 years or younger as of January 1st, 2021, on the initial date of entry into the United States, and who are not admissible for the following grounds. So if you came under the age of 18 before January 1st, 2021, you're in. The bill would mandate that in order to gain lawful permanent residence status, Dreamers would have to participate in higher education and secure a degree or complete at least 2 years in good standing in a Bachelor of Hires degree program or an area, career, and technical education program at a post-secondary level in the United States. They can also complete 2 years of military service or prove a strong record of employment to be eligible. The DACA program was established through executive order by President Barack Obama in 2012 and was intended to be a temporary solution to give immigrants who arrived as children a form of legal status that, Obama and others hoped, would eventually be codified by legislation. Instead, immigration reform efforts have stalled in the ensuing decade, and no major immigration legislation is made through Congress since 1986. Wow. The last time they passed an amnesty, 1986. 1986, I was 17 years old. Diana Poligo, a DACA recipient and a strategist for the National Immigration Law Center, who credits the program with lifting her entire family out of poverty, says, "I'm tired because it has been 11 years and we're still fighting to keep our ability to work and stay in the country that we call home. The rule has now faced dozens of legal challenges and an attempted gutting by Donald Trump and is currently being adjudicated in front of a Texas federal judge appointed by former President George W. Bush." On June 14th, AILA, the American Immigration Lawyers Association, released a first-of-its-kind report on asylum timelines titled High Stakes Asylum, How Long an Asylum Case Takes and How Long Can We Do Better? The report highlights how that more immigration cases are started each year than immigration judges can complete. So there's more being put into the system and less being put out. Obviously leads to backlogs. And over this time, it has led to not only backlogs, but led to ballooning numbers of pending cases, which puts pressure on judges in the courts and even us lawyers, while also having real consequences for the migrants living in legal limbo. For some recent numbers about the backlog increased significantly during the Trump years, and none of the Trump administration's most controversial immigration policies, including the migrant protection protocol, zero tolerance, border enforcement, the Muslim ban, etc., managed to reduce the court backlog. In fact, the backlog increased from just over 500,000 at the end of fiscal year 2016 to 1.26 million by the end of Trump's term in 2020, a backlog of 1.26 million asylum applications. But that's nothing compared to the Biden administration. Between fiscal year 2021 and fiscal year 2022, the backlog increased almost another 500,000 cases, from 1.5 million to 1.9 million backlogged asylum cases that have to be adjudicated by immigration judges. But the backlog is more than just numbers. Reporter Angelamara Vilches published a recent article that highlighted some of these human consequences. Vilches shares the story of a Nicaraguan asylum seeker whose case hasn't budged in 5 years, highlighting the fact that since his application hasn't progressed, he said he can't move on, can't heal from what has been left behind. Donald Kerwin and Evan Millett, both from the Center of Migration Studies, engaged with this important yet fraught topic in a brand new article called "The U.S. Immigration Courts Dumping Ground for the Nation's Systemic Immigration Failures." In the article, they report that there has been a significant shift in the past decade regarding which agency is initiating deportation cases in court. In 2011, Immigrations and Customs Enforcement started most cases. Today, Customs and Border Protection is issuing by far the most notices to appear in immigration court. In fact, according to data, ICE issued less NTAs than USCIS every year since 2015. Now, USCIS is what we might call the immigration benefits wing of DHS. So the fact that they are issuing more NTAs than the enforcement wing of ICE is very significant. Second, Kerwin and Millett compare Congress's paltry funding of the immigration courts, which is much larger funding of ICE and CBP. In 2023, for instance, the EOIR, which is the agency that runs the courts, the Executive Office of Immigration Review, they received $860 million in their budget, compared to Customs and Border Patrol's $20.8 billion and Immigration and Customs Enforcement's $9.1 billion. The effect of this budget inequality is that the courts have too few immigration judges and, perhaps even more importantly, too few support staff relative to the 1.9 million backlogged asylum cases. That's not even all the deportation cases. That's just the asylum cases. Third, Kerwin and Millett argue for a more independent immigration court that would vest immigration judges with greater independence and authority. Right now, they all report to the Department of Justice. And a bill to make the courts independent was introduced last year by Representative Zoe Lofgren, supported by the American Bar Association, the American Immigration Lawyer Association, and the National Association of Immigration Judges. A decade ago, there was very little reporting and research on the immigration court system. Today, the immigration courts have moved closer to the center of the national debate about how to reform the immigration system. The urgency of that debate is only heightened by the fact that 2.2 million people, these are real people with real lives, continue to move on even when their case is not heard by the immigration court. On the afternoon of Wednesday, June 14th, 42 migrants arrived in downtown Los Angeles after a nearly 24-hour bus ride from Texas, where Governor Greg Abbott called the removal much-needed relief for the state of Texas. Abbott said in a statement, Texas small border towns remain overwhelmed and overrun by thousands of people illegally crossing into Texas. Immigration advocates said the arrivals, who were given food, shelter, and legal aid at a church near downtown, included at least 8 children and several older people. Speaking to reporters outside the church, advocates and city officials did not provide a full manifest of those who arrived by charter, but anecdotally, most of them came from Venezuela, Guatemala, Honduras, and 2 from African descent. Jorge Mario Cabrera, spokesperson for the nonprofit Coalition for Humane Immigrant Rights, said they're exhausted, tired, and traumatized. Los Angeles Mayor Karen Bass was away on a planned trip to Washington, D.C. when the bus arrived, but city and Los Angeles County officials had initiated multi-agency preparations Tuesday night when word spread that the migrants were arriving. Since last year, Texas has bused more than 21,000 migrants to cities across the country, according to Abbott's statement. Abbott described the migrants' drop-off in Los Angeles on Wednesday as the first group. It is unclear whether Texas plans to send additional migrants. Los Angeles is just the latest California city to receive migrants from red states, whose conservative governors have gone head-to-head with Governor Gavin Newsom. Last week, we discussed 2 flights from Florida that landed in Sacramento this month, carrying a combined 36 immigrants. Governor Ron DeSantis claimed responsibility for those flights. Newsom responded via tweet by calling DeSantis a small, pathetic man and suggested he can face kidnapping charges. In a statement Wednesday night, Newsom took a more measured tone. He said, contrary to what some think, California is also a border state, but instead of demonizing asylum seekers, we focus on working with local communities to support and humanely welcome them. Early Wednesday, just hours before the migrants arrived from Texas, California Attorney General Rob Bonta said his office had filed a public records request to the DeSantis office and the Florida Division of Emergency Management as part of an ongoing law enforcement investigation into the conditions under which the migrants seeking asylum were brought into California. The migrants who were transported from Texas to California receiving legal support and other assistance from some nonprofit groups, including Sacramento ACT, PICO, California Rural Legal Assistance Foundation, and the Fuel Network. We have a feel-good story out of San Diego covered by NBC7's Priya Sridhar, who appeared on our show discussing her own family's immigration story to the U.S. from India. It's been 18 months since the United States withdrew its troops from Afghanistan, and already more than 78,000 refugees have relocated to the United States in that time. Now some volunteers are helping refugees in San Diego and are saying that they're seeing an increase in recent months of Afghans who have flown to South America and walked thousands of miles into the United States across the Mexico border. Barbara Cummings is one of those people, U.S. citizens, who are helping the recently arrived Afghans. She's a San Diego resident and has been volunteering to help refugees for a few years. And since October, she said she's seen almost 24 Afghan refugees who have flown to Brazil and then walked thousands of miles for weeks across the Amazon jungle to make it to the United States because they're afraid of their lives in the Taliban-controlled Afghanistan. She said, I don't ever want anyone who crossed my path to feel so alone or so helpless. So if I'm in a position to elevate them a little bit and have a little fun, play some ping pong, play chess, just feel okay. If the worst happens to me here, I'll always have food. I'll always have a place to go, but maybe some of these refugees won't. Sharif Ali and Razik spoke in Cummings' kitchen. They're Afghan refugees who she took in. Sharif and Ali both have wives and kids who have been left behind in Afghanistan. Sharif said his daughter is in the 6th grade. Unless he can get his asylum case approved next year, she will no longer be allowed to attend school in Taliban-ruled Afghanistan. The 3 men are all in various stages of their asylum cases, but said that Cummings has been enormous help to them, driving them to medical appointments, court cases, and odd jobs to help them make ends meet. The men said they don't know how they can ever repay Cummings for her kindness and generosity. They hope that eventually they will win their asylum cases and they can get reunited with their families in the United States. And they said they want to work for the rest of their lives helping Barbara with her mission. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.